Mr. Harbeck, usually we've gone from left to right.
If you wish, I'll begin. Chairman Garrett, Ranking Member Waters, members of the subcommittee, thank you for this opportunity today. My name is Steve Harbeck, and I am the President and CEO of SIPC. Since the collapse of Lehman Brothers entities mentioned by Ranking Member Waters in 2008, SIPC has been at the center of the financial crisis. I'd like to give you an overview of what SIPC has done between 2008 and the present day. First, the guiding principle SIPC has used in this period is the greatest good for the greatest number, consistent with the law. I'd like to briefly highlight some of the matters in both Madoff, Lehman, MF Global, and Stanford. The Madoff case is the largest Ponzi scheme in history. The people who have not received funds from SIPC are those people who have either received 100% of their investment back or people who must repay a portion of what they received before receiving funds. The courts have uniformly confirmed that SIPC's method of computing what is owed to customers is in fact correct and in accordance with previous precedent. I'm pleased to note that the GAO report on page 31 that was just issued within the last day indicates that the driver of administrative expenses in the Madoff case is asset collection for those people who have not received 100% of their investment back. The trustee has used the so-called avoiding powers wisely, judiciously, and effectively. The avoiding powers are precisely what makes the trustee's distribution in that case among innocent investors truly an equitable one. The task force on SIPC modernization agreed, and Exhibit D to my written statement demonstrates that SIPC doesn't benefit from the avoiding powers, but those people who are most damaged are the people who benefit. The trustee has also adopted a hardship program to discontinue any avoidance suit that should be dropped given the nature of a defendant's circumstances. It's very important to note that no customer money is used for administrative expenses, and there has been an incredible benefit to investors. I first appeared before this body in January of 2009. And if I had told you then that the trustee would recover $9 to $10 billion for the Madoff investors, you would not have believed me. But that is already what has accomplished to date. And the driver of the $300 million of administrative expenses is the recovery of that $9 billion. Those who would expand the distributions to net winners in the Madoff game should recall that the distribution in a Ponzi scheme is a zero-sum game, and the trustee's plan distributes benefits to those who have been most damaged by Mr. Madoff's theft. If other victims, and they are victims, but people who are net winners who have received 100% of their assets back share in that fund, it is mathematically ineluctable that the people who are most damaged will suffer on a dollar-for-dollar basis. Turning to Lehman. Lehman is the largest bankruptcy in history, and in the early days of Lehman, under SIPC's initiation of a liquidation proceeding, 110,000 customers received $92 billion in 10 days. Second, the trustee in that case has been extremely successful in lawsuits. He's won $2.3 billion from Barclays Bank, settled a suit for over $700 million with JP Morgan Chase, and last week, the trustee scored a major victory in the Supreme Court of the United Kingdom that will benefit American investors directly. The impartial observer closest to the case, the bankruptcy judge, states that the case has been an extraordinary success, and it is coming to a successful conclusion. In the MF Global case, SIPC acted to protect investors and did so demonstrating that we can act quickly and decisively. SIPC placed a fiduciary in charge of the firm less than 12 hours after being notified that customer protection was warranted. As I outline in my written statement, significant distributions to both commodity investors and securities investors have been made. And that brings us to the most difficult subject, and that is the Stanford case. SIPC protects the custody function that brokerage firms perform. Let me say that again. SIPC protects the custody function that brokerage firms perform. The investors in the Stanford case, unlike the investors in the Madoff case, knowingly sent their money away from the brokerage firm to an offshore bank. They were specifically told in writing that SIPC does not protect their investments. They each opened a bank account in a Bank of Antigua, and they now seek rescission of that investment and to have SIPC pay the original purchase price of their investments using SIPC and, if necessary, taxpayer funds. Simply put, Congress never intended, and the statute has never been held, to refund the purchase price of a bad investment. That is absolutely not what the law mandates. And while there are other legal reasons as well, that is why SIPC has not initiated a customer protection proceeding for the firm. SIPC has acted to protect and benefit investors in those three cases, but SIPC's protections are not available to restore the purchase price of a bad investment on a CD issued in an overseas bank. Mr. Chairman, if I could mention, or if I could respond to one of your comments at the beginning of the case, you mentioned that institutional investors would receive most of the money in the Madoff case. This is a point made by Mr. Stein in his written communique, and I think we're failing to connect some dots here that very, very much need to be connected. Mr. Stein mentions that a number of investors received zero in the Madoff case, and that is quite true. So there are thousands of investors who did not receive money. But then when you say 75 to 90% of the assets in Madoff are going to institutional investors, you must connect the dots by saying the thousands of people who did not receive anything are the people who own those institutions, and they will be satisfied by distributions to the institutions. So I wanted to make that clear so that we realize that when the indirect claimants are not paid, they will receive their proportionate share of the distribution when the funds they owned receive a distribution from the trustee. And another point made in the written comments concerning SIPC's actions in this case is that the distribution was not prompt. The trustee stands ready to make a $9 billion distribution as soon as he can, but the people who have initiated litigation to allow net winners to share in that money have delayed that distribution. And if you don't connect those dots, you don't get the complete picture. SIPC's done a great deal. We've advanced $800 million for the investors in Madoff, and we think in that sense the process is coming to a sound conclusion. I'd be pleased to take any other questions you have. Thank you very much.